I'm going to be speaking on the right to gender within the Constitution. What do we mean? What comes within the constitutional right to gender? Is there such a right? Or what is more commonly seen as a freedom from sex discrimination? But how do we understand gender non-conformity within the Constitution? Now, when we talk of gender nonconformity, there is a wide acceptance that gender is now seen to be in a very expansive way. An expanded understanding of gender includes looking at gender expression, which would include a wide range of behavior, dress, grooming, or bodily transformation that comes within the understanding of gender expression. There is also a term used called gender identity, which Akai has used. And within NALSA and within many of the judgments where within the Constitution gender identity is used, it is seen as a category where there are gender variant or gender non-conforming persons which come within it that could be protected. Gender identity includes a person's identity, appearance, behavior, even if such identity, appearance, or behavior is different from what is traditionally associated with that person's gender which is assigned at birth. And I want to kind of look at all of these things within a larger umbrella of gender non-conformity and try and argue that we can have a constitutional right to such gender non-conformity. Now, where do I develop that from? So I first want to look at some developments in the US. I'm going to give some kind of comparative outline because this has been something that has been quite well developed in the US. I want to trace out a few cases and then look at India and then look at some justifications for such a constitutional right. So the US courts have had a very rich experience in addressing issues dealing with gender non-conformity, gender identity, and challenging sex stereotypes. The US has a different legal structure than ours. Of course, it has a constitution, but the US has very strong sex discrimination laws that prohibit discrimination on the basis of sex. And we don't have that. We don't have sex discrimination laws in India. We just have our constitution, which protects or guarantees under Article 14 and 15, prohibits discrimination on the basis of sex. So in the US, the sex discrimination laws expanded the meaning of sex to include not only discrimination on the basis of whether a person is a man or a woman, but also based on sex stereotyping, which has come to include within the definition, so sex stereotyping has been included within the definition of sex for such sex discrimination laws. And such an expansion in the US of the meaning of sex has had a profound impact on the recognition of discrimination, which is faced by a whole range of persons that come within the transgender umbrella. But of course, the journey in the US, I don't think has been very easy. It began with some extremely negative or regressive judgments. And one of the first judgments was a case of Elaine versus Eastern Airlines. And I think some of these cases, the facts are interesting because it tells you the context in which the court ruled. So Elaine was a pilot, U-L-A-N-E. So Elaine was a pilot who was working with Eastern Airlines, and he was a biological male. And when he joined the airlines, he was Kenneth Elaine. He was identifying as a man. And thereafter, she underwent gender reassignment surgery and got a revised birth certificate, and identified herself as a female. When she returned to work as female, she was dismissed from employment. And she challenged this dismissal on the ground of sex discrimination. The court rejected such a challenge, and the court said that this did not amount to sex discrimination because the court interpreted sex discrimination as discrimination against women because they are women, or discrimination against men because they are men. And the court said that the words of the law, that is the employment discrimination law, do not outlaw discrimination against a person who has a sexual identity disorder. So in the US, and I want to just outline this, initially, before self-identification was kind of accepted, the only manner in which you could actually get a sex reassignment surgery is if you could say that you had a gender identity disorder. So that's what the court picked up. And it said that the airlines had not discriminated against Elaine because she was female, but it had discriminated against Elaine because she was a transsexual. She was a biological male who takes female hormones, cross-dresses, and has surgically altered parts of her body to make it appear to be female. And therefore, there is no sex discrimination, because we are not discriminating against her because she's a woman. So that was an extremely regressive judgment in '84. But after this came a really landmark decision of the US Supreme Court in Pricewaterhouse versus Hopkins. And in this case, it's a very interesting case. This was not against a transgender person, it was against a woman. There was this woman, Ann Hopkins, who worked in the big firm, PricewaterhouseCoopers, and she was being considered for partnership, and she didn't get partnership. And one of the reasons she didn't get partnership is because the partners, when her partnership was being considered, the partners made notes saying that she was too macho, that she would be considered for partnership if she could walk more femininely, talk more femininely, dress more femininely, have her hair styled a bit, and wear some jewelry and makeup. And she didn't do any of that. And so she challenged the rejection of her partnership consideration. And the Supreme Court said that these partners' comments showed sex stereotyping at work, and held that an employer could not evaluate employees by insisting that they match the stereotype associated with their group. And it held that the sex discrimination law forbids them to discriminate against individuals because of their sex. And this could also be discrimination resulting from sex stereotypes. And the court said that any discrimination against an employee on the basis of sex stereotype, that is a person's non-conformity to social or other expectations of that person's gender, also constitutes sex discrimination. So for the first time, in the Pricewaterhouse case, sex was expanded to include gender, to have the concept of gender, and to include an understanding of sex stereotyping, and that would amount to sex discrimination. And I think Pricewaterhouse opened the door in the US for recognition of gender non-conformity, that where there is bias against individuals, against their gender identity, or that they do not conform to any social or cultural expectations of sex on their birth sex, is also coming within the umbrella of discrimination. There were two other cases which actually had a positive positive finding after Pricewaterhouse. And I'll quickly go through them. So there was one case of Schwenk versus Hartford in 2000 where they applied this reasoning to transgender people. And in this case, there was a transgender woman who was in prison, and she was kept in a all-male prison, which is something that happens very commonly everywhere. It happens in India. We have seen that in our own work that we've done. So she was kept in an all-male prison, and she was sexually harassed and assaulted there. And when she sued for the violence that she was made to face because she was placed in the all-woman prison, the court held that transgender persons are protected under sex discrimination law. And the reason she was put in an all-male prison is that she didn't present herself as female. And so the court said that to demand that a transgender person present themselves to society in a way that matches the stereotype associated with their birth-assigned gender is gender stereotyping. And this was in the context of, where someone was in prison. But another interesting case was, again, in the context of employment. And I think employment is, yeah, I'll actually share with you my presentation. Another case of 2004 was Smith versus City of Salem. Here there was an employee who was in the fire department of the city, and Smith was initially a biological male. But after he started expressing a very feminine appearance on a regular basis at work, started dressing femininely, wearing women's clothes and makeup. And due to this, co-workers began commenting on his appearances and reported this to the management. And then his supervisors said that this was unmasculine conduct, and then forced him to undergo repeated psychological evaluations at work. He went through it, and then finally, on account of some other unrelated misconduct, this person was fired. When he when he challenged this, the court actually upheld his challenge and said that this amounts to discrimination on the basis of sex stereotypes and non-conformity of gender, and held that this is not permissible and this amounts to discrimination. So I think there is this kind of recognition in the US where under sex discrimination laws, the meaning of sex has been expanded to include gender, to include gender non-conformity, and to include discrimination against sex stereotypes. And that has actually opened the doors to address many forms of discrimination that transgender persons are facing. So what is happening in India, and can we borrow from this jurisprudence to say that can we argue for a similar right to gender non-conformity in the Indian constitutional context? So in India, of course, we have the landmark Nalsa decision that came out in 2014, where the Supreme Court actually recognized for the first time that there is a right to gender identity. And so I want to trace how the court looks at gender non-conformity within NALSA. And what was interesting is that when the court defined transgender, I know that there could be certain criticisms of it, but I just want to say what the court held. The court said that NALSA was an umbrella term for people whose gender identity, gender expression, or behavior does not conform to their biological sex. And it used this term to describe a whole range of identities and experiences which are not limited to pre-operative, post-operative, non-operative transsexual people who identify with the gender opposite to their biological sex, whether it's male or female. So it gave a very umbrella term. And I think what the umbrella term at least is useful is because it talks about behavior or identity which does not conform to your biological sex. So can we use that as a definition for gender non-conformity? It defined gender identity as a person's deeply felt internal and individual experience of gender, which may or may not correspond with their sex assigned at birth, including a personal sense of the body, which involves freely chosen modification of bodily appearances or functions, either medically or by other means. And it held that a person's gender identity is integral to their personality. So in NALSA, the gender identity was brought within the definition of sex under Article 15. So Article 15 under our Constitution guarantees, protects that, guarantees that there shall be no discrimination faced by any person on the ground of sex. And NALSA brought gender identity within the meaning of sex. And I would actually say that gender identity would include gender non-conformity within the same Article 15. Interestingly, what has happened after NALSA? Have there been other decisions which have followed NALSA, and have they been any different? There was one case of the Madras High Court, where again, it's a very interesting case because there was a woman who was who was not allowed to be in the police force The woman claimed to be a woman. She was born female at birth. She was assigned a female gender, and she all along claimed to be a woman. But she was sent for a medical test without her will. I mean, she was forced to undergo a medical test. When she went for a medical test, the medical test marked her as transgender based on her medical examination. But she said, well, I don't identify myself as a transgender, I identify myself as a woman. And the court, the Madras High Court said that, well, she has the right to have a female, her gender identity includes the right to identify herself as a woman. And you cannot compel someone to even undergo a medical test to decide her gender identity. However non-conforming it may be, and we don't care what the medical team found in her examination. That is immaterial. If she identifies herself as a woman, that is what her identity would be. So I know I'm kind of running out of time. Yeah, that is Jacqueline versus state, I think. But I'll give you those decisions. So, this is how the courts have held. So why should gender non-conformity be constitutionally protected? What is the justification for that? Or, what is the constitutional justification for that? And the decisions and academics have given different justifications. There is one writer whose work I found very interesting called Julian Weiss, who does not talk about gender non-conformity, but she talks about the constitutional right to gender autonomy. So it's again, it's a slightly different term. So she uses the term gender autonomy, and her justification for a right to gender autonomy stems from the privacy right. And in the US, that is a very strong, well-developed right, and she relies on the definition given by Lawrence Tribe, where he says that the single core common to all of what passes under the privacy label is autonomy with respect to our most personal of life choices. So she gives that basis that if you have a strong right to privacy and autonomy to decide our most personal life choices, that includes the constitutional right to gender autonomy. So that is one kind of articulation. And in NALSA, the argument, the kind of phrase used is gender identity. We don't use the term gender autonomy in India, but I think it's an interesting phrase which stems from the same principles that were there in NALSA. And in NALSA, the term gender identity, which can be an umbrella term which also encompasses the right to gender non-conformity. What was the justification? So the court said that gender discrimination on the ground of gender identity would violate equality before the law. So there were principles of equality. There were principles of dignity and privacy. So the court expanded the meaning and said that it used the values of dignity, autonomy, and privacy, and said that gender identity lies at the core of one's personality, identity, gender expression, and it has to be protected under the right to life and under Article 19(1)(a). And it went on to say that gender identity lies at the heart of the fundamental right to dignity. So it framed the argument of the right to gender identity under the dignity argument. And of course, the right to dignity, the right to live with dignity is a well-developed principle within our Constitution under Article 21. And it guarantees dignity includes the right to personal autonomy, and the court said that personal autonomy includes not only the negative right, but also a positive right to individuals to make decisions about their lives, to express themselves, and to choose what activities they want to take part in. So it gave a very positive right to autonomy and dignity. So I'd like to conclude by saying that we look at gender non-conformity, issues of gender identity in a variety of situations. We look at it at work. These situations come up in personal relations. They come up everywhere, all the time. And how do we address it? They come up in, when you're talking about birth certificate changes, identity document changes, passports that Akai spoke about. And how do we address it? Do we address it by, one argument is that you address you address it by expanding our understanding of sex and gender. And I would like to conclude by one interesting piece of writing by Catherine Frank. She's written a lot on sexuality and transgender rights, and she argues that we've been looking at different ways of how to take the trans rights movement forward. We're looking at the trans rights bill. So one way has been to have a separate legislation on transgender rights. But another way is, as Catherine Frank said, that instead of adding transgender or transgender people into a list of identity groups or statutes, we should instead seek to robustly interpret what our sex and gender-based discrimination laws should prohibit. So why don't we look at an expansion of gender and sex? And maybe if we look at some of these examples and the way in which other courts and our court has expanded the notion, maybe that can be a way forward.